Up there by the table. Do you have the tax pass? Up on the table itself. No, like where the lawyers are talking.
There's a speaker above your head. You can get. You can
I know,
sound
but
over
it sounds
that.
better if I put it right up by him.
I know, but
Oh, it sounds like it's down a hallway.
I asked about the podium and asked about the tables.
Oh, you put the podium.
yeah,
I
those,
didn't put any.
Oh.
I didn't-
they'll shoot you down on that.
yeah.
Because last time I was there, they let us put them up.
Yeah, we can't put it on.
Oh, can't put it up at the lawyers.
If they move around, they might not.
Yeah, but I can just set it there. It's not up here. Because it's a public meeting.
Right. We got audio.
But if I just set this up there, it's not bad.
Hi, Don.
Hi, how are you?
But last time I was here, we had one over there and then one over there.
I know. About the only place I was with, you got that right.
Yeah, that'd be all right.
Sure. I know other times you guys have put them on top of it.
Yeah, that is
You guys, there's a conference room right next door that's open. Also, it's going to have live stream. Hear it and watch it in there as well.
And it's going to be live streaming on the internet, right?
Correct.
They're going to watch that.
So if you guys have those,
I was going to set that on the white table that you pointed to the middle of the room.
Yeah.
Picked up pretty good. Kind of like cord.
get it up there before anything starts.
Take a break.
Yeah, that's good. Solidarity.
Good morning. It's Thursday, May 25th.
Are you really here?
Test. It's working now.
Oh, no, thank you. Just got some gum. Thanks, though.
You're welcome.
Test.
You got it.
Where's your shirt? Oh.
I think they should have reserved a bigger room. Lights are being dim because the screens are coming on.
They can't turn it on in the winter with summer show.
This is the IUB, Iowa Utilities Board. Another hearing on the back end pipeline.
The Iowa Utilities Board is now in session. The date is August 25th, 2016, and the time is 10 o'clock a.m. We are in the hearing room at the IUB OCA building in Des Moines, Iowa. This is the time set for oral argument regarding the petitioner's motion to stay in docket number HLP-2014-001. Before we proceed further, I would just like verification that all the landowners have seats in this room. Mr. Hannigan, can you verify that for me? And as a reminder for your mics, the mics need to be as close as possible. The green light needs to be on.
Chair, we believe that all the landowners who are present are in the room and have a seat.
Okay, any time any landowner shows up that does not have a seat, we will bring another chair in for them. So you will need to advise us of the same.
Will do.
As an initial matter, the board has two motions. One is a motion to dismiss, and another is an emergency motion to dissolve the temporary remedy, both of which have been filed by Dakota Access. The board is reviewing those filings and will issue a ruling at the time it rules on the petitioner's motion for stay. If the parties also wish to address that filing during their arguments today, they may do so, but they will not be given any additional time. The board would like to remind the parties of the procedures for today. Petitioners will have 45 minutes to present their argument. Dakota Access and other parties who are aligned with it will then have a total of 45 minutes of response time, with 40 minutes for Dakota Access and 5 minutes for, actually, it's my understanding that it will be a full 45 minutes for Dakota Access. Petitioners will then have 10 minutes of rebuttal time. The board understands that the Office of Consumer Advocate did not request any argument time for today. However, the board will recognize the OCA at any time prior to adjournment if it wishes to participate. During the presentation of arguments, the board members may also have questions for the parties. We are not going to acknowledge and are going to allow the board members to ask the questions as we proceed forward. I understand that there's been requests for utilization of your desk mics. We are requesting that you use the podium, and the reason for that is because because the camera does not pick up the front of your faces while you're sitting at your tables. If you need that table in a different location for your papers and documents, we will adjust the same, and we will not allocate any of your time until you begin speaking. At this time, I am recognizing, for appearances purposes and as part of the record, Mr. Dublinsky for Dakota Access, Keegan Piper, and Brant Leonard. For Maine Coalition, I have Matt McDermott. I have Jim Piazza, also representing multiple parties. We have OCA, Mark Schuling, and John Long, and Mr. Hannigan representing the petitioners. Could you please state your name for the record so we have it?
Jason Lawrence.
Thank you. Are there any preliminary matters to come before the board? Mr. Dublinsky?
Your Honor, you recognize the two motions that are outstanding. We would just note that those become largely moot, which we think is inappropriate if they are held until the time of the ruling on the merits of the motion. We would note that as we sit here today, my understanding is that petitioners still have not complied with the material they were required to comply with by 2 o'clock yesterday afternoon. That certainly is prejudicial to us. We at the very least want to make a record of that fact. We think it is grounds for dismissal. The board has jumped through amazing hoops to respect their claim this is an emergency. Dakota Access has jumped through hoops to respect their claim this is an emergency. If they can't do the same, then they really have no right to be here on an emergency basis. It is prejudicial that we do not have the information that the board requested. We think it should be dismissed. Second, we think Board Member Wagner was absolutely correct that the board simply has no authority to issue any kind of a stay without the 4 factors of being part of the test. We think he did not go far enough. It actually is a significant violation of our due process rights to not have a pre-deprivation hearing. And we would reiterate our request that that be resolved immediately.
So, Mr. Hannigan, as you've observed, we are moving into some of the issues that we were going to have during 45 minutes. If you want to remain at your desk until we start the oral arguments for the temporary matters, that is fine. Do you have any issues that you wish to bring before the board prior to our proceeding?
I'd like to respond to Mr. Dublinsky's remarks and objections. First of all, with respect to the board's request for information from the landowners, the landowners have collected, I believe, 6 or 7 affidavits, and the order of the board allows the landowners to present those at the time of the hearing, and we ask that the board admit those at this point. The remaining landowners, of which is approximately another 7, we do not intend to collect affidavits from the landowners with respect to those properties. We recognize that Dakota Access has filed a table with respect to all the properties, and we're willing to accept their table with respect to those remaining 6 or 7 properties as being accurate for purposes of this hearing. Secondly, with respect to the motions that were filed by Dakota Access over the nighttime, we've recognized this morning that those motions have been filed along with a substantial amount of exhibits. We have not had an opportunity to review those. However, we're willing to review those and respond. In fact, we intend to respond to those motions by brief, possibly by the end of the day, if not then by Friday.
Are there any additional matters that either of the parties wish to bring before the board before you begin your oral arguments?
Only to state that their efforts to brief should not further delay, particularly our getting back to work, and the fact that the board issued the temporary stay sua sponte means that they can dissolve it sua sponte and there's no need to wait for the other side to brief the issue.
Mr. Hannigan?
The board, of course, has authority to act under its own powers at any time. We do not ask that our responsive timing to these new motions delay the board's intent to respond to all three motions simultaneously. We do not, barring a further progress in these proceedings, expect the board to extend its stay beyond Monday, unless, of course, it becomes necessary during the course of these events to ask for an additional stay.
The board will take your comments under advisement. At this time, we would like to proceed to oral arguments. Mr. Hannigan, as soon as you are ready at the podium, and if you need the table moved or changed in any way, we will start your time. Like to remind you again before we begin that the board members may be interrupting you to ask questions, and if you've not been through a utility board state proceeding or oral arguments, we wanted you to be aware of that.
Good. I'm looking for an interactive process.
All right. You may proceed.
May it please the board and council and honored guests, my name is Bill Hannigan. I'm an attorney for the interveners and petitioners in this case. I suppose as a matter of housekeeping, when we, prior to the time that the order, the final order that is, was issued, we spoke of interveners. Since we've been in the petition for judicial review, we've talked of petitioners. I'm going to probably just say petitioners. I think we all know who we're talking about. We're talking about the landowners. First, we'd like to thank the board for making itself available for this emergency hearing on these important issues. And the central issue in this case is the question of whether a private entity, which provides no services whatsoever to Iowans, may nonetheless utilize the state's police power to take private property from private citizens for its private purposes and its private profits. The only question before the board today, however, is whether the board should stay the pipeline company's permit to trench and construct across now only 14 specific farms. On Friday there were 15. The 4th or the 15th in Cherokee County has since been trenched and the pipe has been placed. The ground has been covered back over the pipe. And thereby that stay holding the parties in their status quo long enough to answer the first question. Given the recent guidance of the district court, the petitioners respectfully seek a stay from this board until the district court can give them due process. Dakota Access has argued and will argue that it's too late for the Constitution and too late for due process. It argues that if somehow the petitioners had only sought to protect their constitutional and statutory rights sooner, then maybe it would be different. I suspect, however, that Dakota Access would argue against this stay and against the petitioners, regardless of the timing of this motion. It's important for our motion for stay that the board did not, in its final order, opine about whether Dakota Access was a utility. It's equally important that the board did not opine in its final order about whether Dakota Access is a common carrier under Iowa law for the purposes of Chapter 6A. We believe that because Dakota Access is neither a utility nor a common carrier under Iowa law, it may not utilize the power of eminent domain because of the operation of Chapter 6A. We further believe that because Dakota Access is a private industry, which the board did find in its order, and because it has a private purpose, it is prohibited from exercising the power of eminent domain by both the Constitution of this state and the Constitution of the United States. The primary objection here to this motion is the question of its timing. Specifically, there is to the question of whether or not the motion was timely. The landowners have filed a statement of counsel. And that statement of counsel is ratified by their individual affidavits. And the question posed by Dakota Access is, gosh, why didn't you file your motion for a stay with the Iowa Utilities Board on March 11th? There was an order on March 10th. Well, as we all know, that order was not effective until April 28th. And we know this because many of these same petitioners filed their petition for judicial review, and the board, joined by Dakota Access, objected to the timing of it because of an outstanding motion to reconsider. So although we talk about a March 10 order, it's really an order that wasn't lawful and effective until April 28th.
So then, Mr. Hannigan, the question is, why wasn't the stay filed on April 28th or April 29th?
The answer to that question is because of the resources and the other options that were available to the landowners on that day. One thing that you've got to understand is that following the effectiveness of this order, there began at that moment a statewide blitz on the landowners. And with respect to that, I'm going to refer you to the exhibit to the statement of counsel, which is the affidavit of Danny Manning, or I should say Daniel Manning Sr. Dan Manning Sr. has been an eminent domain lawyer operating under Chapter 6B in this state for over 30 years. I'll suggest to you that he is one of, if not the premier eminent domain lawyer in the state.
Your Honor, we would object to the consideration of that affidavit if it's not filed timely.
Again, Your Honor, you'll recognize that the landowners had right up until this moment, I should say by the end of this hearing, to answer to the board's questions pursuant to the board's order.
That is not true, Your Honor. It was 2 o'clock.
Mr. Dublinsky, we're going to allow him to proceed if there's any objections that you wish to raise, or if there's any objections that Mr. Hannigan wishes to raise about anything you state. We will allow you to address those in your while you are making your presentation.
So the answer to your question is why the landowners, these 15 people, didn't get together and file their motion on April 29th, is that because on April 29th, Dakota Access, represented by 2 of the biggest law firms in the state, plus a host of people in Texas, all landed on those landowners in a statewide blitz for condemnation.
And so, did that condemnation process, or is that procedure allowed by law?
The condemnation process and procedure is a procedure designed for condemnation by public entities and utilities.
But so the condemnation process that they followed, was it legal or was legal?
The condemnation process that they followed, and if you look at, again, the affidavit of Mr. Manning, which, by the way, the board may take judicial notice of, and as much as it was also filed in the petition for judicial review. But Mr. Manning identifies in his brief, or excuse me, in his affidavit, that the procedure was, in his opinion, not pursuant to the good faith negotiation requirements of an acquiring agency, be that a public agency or, in this case, a private company.
So which jurisdiction then has the ability to hear whether or not that was or was not good faith? I don't believe that's been raised in anything that's been filed before the board. So do we have that jurisdiction, or does that jurisdiction lie with the condemnation proceeding?
This board, which has the authority to provide eminent domain under Chapter 479B, which, that authority triggers both the application of 6A and 6B. So I would say that this board has the authority to address the question of whether or not eminent domain is being followed in good faith. I believe that the district court, that is the district court under the petition for judicial review, can consider that question. And I believe that landowners under Chapter 6B can raise and pursue the question of what I'll call bad faith in their individual 6B petitions, or I should say in their individual 6B appeals. However, as you probably know under 6B isn't really about the question of whether a party may condemn. It's mostly about valuation. So for that purpose, because this board has authority to manage the condemnation process, or at least to issue condemnation authority, I think this board has authority to consider this question of bad faith.
So you think our authority goes well beyond our decision of our March order, in that eminent domain could be granted and follows throughout the condemnation process. So there, would you then also argue that the board still has jurisdiction on condemnation parcels, and if a landowner has a disagreement or wants to appeal a condemnation decision, then it would appeal that decision to this board or to some other court?
We're indeed appealing it right now. I mean, this motion to ask you to...
This motion is for the stay,
right,
not necessarily the merits of our decision, because that decision is currently with the district court. Is that correct?
In under chapter 17A.19.5, this board has authority to consider and must consider the elements of a motion for a stay and whether or not it should grant stay. It has to consider the possibility of irreparable harm. We argue that the loss of our due process rights is in itself an irreparable harm, and we cite good case law for that. And also, this board has authority and a responsibility to consider the question of whether the landowners are likely to succeed on the merits once they ultimately get to a full hearing on the merits. And that goes to your question in your dissent, by the way, which is how can this board, the majority of this board, issue this temporary stay? I'm talking about this intermediate stay until Monday. And the reason that they can do that is because when they balance those four factors, the probability of success on the merit, or the likelihood of success on the merit, doesn't require 51%. It's a balancing test. And so if the irreparable harm is great, as we think it is, you know, it's not just taking their farms and plowing them up and putting a trench down there. It's doing it before they can get to the district court and get to that district court and seek relief, which is where due process has to happen in the Constitution. And the reason that your intermediate stay was correct, and the reason that you should issue a more extended stay to get through the timing of the petition for judicial review, is because if you don't do that, then the petition for judicial review is meaningless. And the reason it's meaningless is because today, under Chapter 6B, all of these landowners have received a valuation, a fair market value, from their county commissioners. And indeed, it's happened, and Dakota Access has deposited a check with either the individual or the sheriff. And so they're already entitled to fair market value. If you don't give them a stay, then at the end of the petition for judicial review, if the district court finds that eminent domain was improper, and if the Iowa Supreme Court affirms the district court and finds that eminent domain was improper, then Dakota Access is going to argue that under this case called Nichols versus City of Evansdale, the landowners are entitled only to money damages. So they can have their money damages now, or they can have their money damages later. And that's all they get. And that makes the petition for judicial review meaningless unless there's a stay, and that is unless this board grants that stay. And so we talk about what's your authority, what laws do you enforce? Well, you've got to look at all the laws. Certainly the code gives you power to act under a limited set of laws, but you've got to consider all the laws, and that includes due process. And if you don't give us the stay, then the petition for judicial review doesn't mean anything. And that means that Chapter 17A, the Administrative Procedure Act, doesn't mean anything.
Mr. Hannigan, isn't it true that you brought this this issue and this argument up in 2 other court proceedings? Other than the Polk County hearing last Friday?
Some of these petitioners, but not all of them, brought actions in Cherokee County District Court and Calhoun County District Court under section 68.24, parent 1.
So how is your argument in district court different from those 2 cases?
With respect to this irreparable harm and the fact...
Set aside the stay. Let's get to the merits of what's the difference between those cases. If we've had 2 district court judges already rule, what's different about this case?
Those other 2 district court judges, they ruled on jurisdiction. So what they said was, no matter what else, we think that Chapter 17A controls and that we district court judges in Cherokee and Calhoun counties, we don't have jurisdiction under 6824.1 because it's just a case proceeding which triggers the application of Chapter 17A, which provides that it is the exclusive remedy for appeals from an administrative act.
So when you've gone through the condemnation proceedings with these landowners and you get to the point where there is a ruling on compensation, what are your appeal rights from that condemnation hearing?
From the condemnation hearing, the only appeal rights are about value.
So when would you have been able to bring an action related to the taking of property under eminent domain laws? Was that from our board order, whether it's the March, April, or June?
The petitioners under the law could have filed this if they could have, been all on the same page, and if they had been able to organize their capital, they could have filed a motion for stay with this board after that April 28 ruling became effective. They did not, because 6824 provided them a route that got them directly to the district court. And it's important that 6824, which came about in the 2006 Act, doesn't have any published decisions that opined or concluded that 6824 is not an alternate remedy to 17A in this instance.
I have several questions. Going back to the timing, as you mentioned, whether, as Cherokee just said, it's March, April, or June, you were in attendance to at least some of the proceedings in Boone and are familiar with the timeline that Dakota Access offered that the company planned to follow if a permit was granted for this project, correct?
I was there for 2 days. In that time period, my scope was different than it was today. One of the things that we argue is that virtually all of these landowners had to change lawyers and law firms during that same window.
But part of the evidence in the record indicated the timing of the potential construction of this project, which indicated it was on a relatively fast pace, and that Dakota Access was interested in getting that project completed the end of this year or into early next year, depending on weather, correct?
I assume that it was, yes.
So when I read the statement of counsel, I believe that's where I read it in, at least one of the filings that you made very recently, it indicated that, I think it was a statement of counsel, and it says the landowners would have reasonably expected County Compensation Commissioners meeting to have occurred in November 2016. When it was obvious that things were going to move much faster than that, why would those landowners, you've introduced evidence with an affidavit by Mr. Manning, but outside of that, it was very obvious to most parties watching this case that things were going to progress fairly quickly. Why then wouldn't the landowners have asked for some sort of remedy or stay back in June? I'm not sure where their thinking came that condemnation proceedings weren't going to occur until later in the year and possibly into November.
we all live in the practical world. Board Member Jacobs, and I'll direct you back to Mr. Manning's affidavit. So what you had then, once that order became effective, was a process where I believe there were 1,200 different parcels. And at that point in time, I'm recalling that, and the point in time I'm referring to is April 28th, that less than half, or possibly just more than half of those landowners had provided, acquiesced and provided voluntary easements. So what you had at that moment then was you had the remaining 600 landowners, in my example, my presumed fact. You had the remaining 600 landowners all had to go out there and find qualified appraisers to come forth and go to their properties and give them appraisals so they could go to the 6B commissioner meetings and have evidence to defend the value of their farmland in the event that eminent domain was affected. So one of the things that was unconsidered, and I think legitimately unconsidered by the board when that order was made final and when that calendar was considered, was the practical issue, which is how do all those 600 landowners approach a handful of actual qualified persons who are certified appraisers who have provided evidence and testimony in 6B lawsuits and prepare to defend themselves in those 6B proceedings.
Mr. Hannigan, why I may not remember every exact number, I don't believe the board granted the power of eminent domain on 600 parcels.
Oh, yeah,
I think those numbers are quite accurate.
I think that's right. I think that's right. I think I've never counted the full number, but I think that the number that's in that final order is, certainly less than 100.
Much less, yes. So then I would like to turn quickly to the chart that you referenced that was provided by Dakota Access of the landowners and the progress on the land. And you indicated that at least some of your landowners who are petitioners, you would accept that chart. And I just want to verify a couple of things. First of all, for the very bottom, Marion Johnson, who is listed as one of the landowners as a petitioner, it indicates that that property is complete, and I believe you indicated that this morning that they're into land restoration. What remedy outside of monetary would be appropriate for that landowner at this juncture?
Board Member Jacobs, that's our point. Our point is that unless you put in a stay on those remaining properties until the petition for judicial review is complete and decided, the answer is that neither this board nor the district court can give them a remedy.
So Marion Johnson at this point, it's done. It's up to land restoration, and that is it. Then we see that the remaining properties, it appears, will start somewhere around as early as next Monday for some processes that could be in place. Once again, there's been some clearing. It's been completed on most of those, or on many of those. Staking has been completed on all, except Liver and Johnson. I mean, outside at this late date, outside of monetary, I think the board's very interested in understanding what other remedies are available to these landowners.
Yeah, the universe of remedies is I think complete, and that is either an equitable remedy, which is the one that we're asking for, which is let's push pause on those remaining 17 properties until the district court can do its job, so that its job has a purpose.
Mr. Hannigan, then, if there are, and my numbers won't be perfect either, I believe there are over 1,200 properties. If we take 14 properties to halt this process, what about the due process of those remaining 1,100, over 1,100 property owners?
The remaining
in the agreements that they signed, and that's, what about their harms and damages and due process?
The remaining property owners, I think you have two general classes, which are the persons who have executed voluntary easements, and you have persons who are subject to condemnation who are not among these people. The persons who've executed voluntary easements, I think that they have selected their remedy, which is a cash payment. The persons who are in condemnation but who are not among the petitioners in this case, I think that by not exhausting their remedies, if you would, they have also selected the remedy of cash payment, although at that time determined by the county commissioners. So this, I think the universe of people that you can help are the people that own these remaining 17 properties, which I think is approximately 14 persons.
And their due process trumps the due process of the remaining landowners on the property.
Absolutely. That's what the Constitution's about. So, the question of the statement of council, I think we'll move on from that, and if you have additional questions about that, I'm willing to address those.
I would like to stay here for just a brief moment on Marion Johnson's property. Do you know approximate dates for grading and trenching?
First of all, I don't think, well, I guess I'll take this as completed. I spoke with the landowner's attorney yesterday, and he personally went out. The affidavit with respect to Marion Johnson is executed by her attorney. Marion's in an assisted living facility, and her husband lives on the farm. And he told me that in his lay view that the land hadn't been graded. The Dakota Access indicates that possibly it has or hasn't. I think that the timing that happened, we should say when that pipe was installed, was late last week and possibly over the weekend. I think Dakota Access could provide more accurate information about that.
So back to then a timeline. If we're looking at some of these that are complete staking, initial clearing and grading, at some point, our rules require that they would provide notice. And arguably that notice was probably provided before last week or this week when the stay was filed with the board. But why is this, and it goes back to the question, there was ample opportunity to file a stay, not only with the courts, but with utilities board.